If you're struggling to create a successful parenting plan, you need to focus on the children, and you need to focus on what works for the children. And that includes being a good role model for the children, for being present for your children, and for really keeping a line of communication open between you and your spouse or ex-spouse that allows the two people to work together and act in the best interest of the children and to be active parents with those children. It's important to keep in mind the needs of each of your individual children and to meet the children at their needs and to do your best to fulfill them. Now, each child will have different needs and require different aspects of attention in your life, and as important it is to do things with each child as a whole, or with both children or all of the children, you also need to dedicate time to spending time with each children individually. And this becomes even more important as you're going through a divorce and as you're post-divorce. And dedicating time to have special events with each child will help you in the divorce process, because that child's going to want to spend time with you, and it's going to increase the relationship. I can't tell you how many times a child leans towards one parent or another over a divorce, and the parent will expand upon that and they'll use it to their advantage. That's called alienation. Parental alienation is a real problem, and it can be done in a subtle manner or it can be done in an overt manner. You really want to work hard to not allow it to happen, and if it's happening, you want to identify it, you want to write down the example of parental alienation, and you want to keep track of it and bring it to your attorney's attention. That's going to be a key component to being successful in your divorce. Flexibility in a parenting plan is key. We do our best to create a written parenting plan that's written in a manner that promotes flexibility. We try to allow for an exchange of parenting time with kids in as equal of a manner as possible. If kids have a particular sporting event and it's on one parent's time, gaining the support of the other parent is super important. Working together to be flexible will ensure that your child's best interests are met and that you don't screw up the kids in the process. Setting forth clear parental expectations is key. It's what's going to ensure a smooth transition from being married in a broken relationship to being separated, healing in the process, and moving forward. It's going to ensure that transitions between parental homes is smooth. It's going to lower conflict between parents, which in turn is going to create a lot less damage to the kids. And it's going to allow for a much more successful relationship, not only with your ex-spouse, but also with your children. Martino Law Group does a great job at crafting a detailed parenting plan that allows for the amount of rigidity that's needed in the situation, yet providing flexibility to allow the people to make changes. Much like a legal document would set forth the parameters of what is permissible and not, our parenting plans are not written with such rigidity that they can't evolve with the life and aging of the family. As kids get older, events happen, and we want to make sure that we have a parenting plan that's written in a way that'll evolve with the family, that'll satisfy each of the people's needs, and that'll grow with the children. It's never a good idea to violate a custody agreement. There are serious consequences that are gonna affect your life. Instead, a better way of doing it is to try to work out an alternative agreement that you can have with your spouse or your ex-spouse, put it to writing, go to court, and file for a joint modification. If you and your spouse can come to an agreement as to a better course of action than is currently the present parenting plan, it's gonna ultimately be a winning situation. Violating a court agreement can end up with sanctions, can end up with court hearings, will require various days in court, attorney's fees that are gonna spiral out of control, and could end up in potentially a contempt action that the other party brings that could leave you with fines, penalties, and even under some circumstances, jail time. Don't violate a known court order. Avoid the terrible ramifications that can occur. Instead, reach out to us and we'll put together an action plan to successfully allow you to alter the parenting plan or court order to meet the needs of yourself and your children. Clients often come to me and they're either considering violating a court order or have violated a court order. And the clients who come to us before it occurs always have a much better result versus having to start on the defensive side and having to craft an argument against that violation, which oftentimes is a losing argument. Instead, come to us, reach out, let's put together an action plan that logically will get you to the conclusion that you want instead of acting from a moment of anxiety or fear or emotion. When you make decisions based on emotion rather than a well thought out, reasoned plan, the results are never the same. They're not going to get you the results that you want when you're making decisions based on emotions. Instead, let's set aside emotions, come up with an action plan that works, and try to come up with an agreement without having to go to court and getting court approval. Instead, we can enter a stipulation in and come to an agreement and do it in a much easier, simpler, less emotional, and cost-effective manner. Let's talk about the different ways of modifying a child custody agreement. In Massachusetts, in order to modify a child custody agreement, you have to come up with an agreement and file a modification with the court. Sometimes an existing child custody agreement isn't working for the individual facts of this circumstance of the family. Instead of going and violating an order, we recommend you contact us and determine what the best course of action is. In order to modify a child custody order, we need to have either agreement of the party or an order of the court. It's important to find out what the best interest of the children are if it involves children and set forth an alternative to that child order to allow the parties to move forward. We have years of experience in working with individuals not only to craft orders, but also to develop and work on orders that aren't working. We can draw from our years of experience in family law to come up with a plan that works, an agreement that works for all parties, and one that the parties can follow in the easiest possible manner.